Hello everyone. Today's video contains the topic of appointment of directors. The various methods of appointing directors of a company are: Number 1, appointment of first directors. Number 2, appointment of directors by shareholders or members in general meeting. Number 3, appointment of directors by the board of directors. Number 4, appointment by proportional representation. Number 5, appointment by the order of the tribunal. And number 6, appointment by the central government. Now, let me discuss these points one by one. The first one is the appointment of first directors. The first directors are appointed as per the method or regulations laid down in the Articles of Association. It means that the articles may list the names of the first directors. If no provision is made in the articles for the appointment of first directors, the subscribers to the memorandum, who are individuals, shall be considered as the first directors of the company. They shall hold office only up to the date of the first annual general meeting. Next point, appointment of directors by shareholders or members in general meeting. The members of a company have a right to appoint directors of the company at its general meeting. The legal provisions regarding the appointment of directors by shareholders are contained in Section 152, subsection 6 of the Companies Act 2013. These provisions are applicable only to a public company. Section 152, subsection 6 states that not less than 2/3 of the total number of directors in a public company must be liable to retire by rotation at its annual general meeting. And maximum 1/3 of the total number of directors may be non-rotational, that is, they may be appointed for a fixed period. Rotational directors have to be appointed at general meeting except where the Act otherwise provides. For the purpose of calculating the number of rotational directors, total number of directors shall not include independent directors. Out of the total number of rotational directors, at least 1/3 of them shall compulsorily retire at every annual general meeting. The retiring directors are eligible for reappointment. Let me give you an example to explain this point. Example: ABC Limited has 8 rotational directors on its board. Suppose the name of the directors are R, S, T, U, V, W, X, and Y. Out of these 8 directors, 1/3 will retire at every annual general meeting. 1/3 of 8 is 2.67. When it is rounded off, it is 3. It means that 3 out of 8 rotational directors will retire at every annual general meeting. Next point, appointment of directors by the board of directors. The power to appoint directors by the board of directors is contained in Section 161 of the Companies Act 2013. The board of directors may appoint directors of the following nature: additional director. Additional director is appointed if company needs some more directors in addition to the existing director. Alternate director. Such director is appointed during the absence of a director for a period of not less than 3 months from India. Director for filling casual vacancy. A casual vacancy may occur by death, resignation, insanity, insolvency, etc. of the director. If the office of a director is vacated before the expiry of his term of office, it is called casual vacancy. The board of directors may fill a casual vacancy by passing a resolution at the board meeting. Next point, appointment of directors by proportional representation. The legal provisions regarding appointment of directors by proportional representation are given in Section 163 of the Companies Act 2013. This section is not applicable to a private company. According to this section, the directors shall be appointed by the system of proportional representation only if the company's articles of association provides for appointment by this method. The articles of a company may provide an option for the appointment of not less than 2/3 of the total number of directors in accordance with the principle of proportional representation. Proportional representation may be decided by 2 methods. Number 1, single transferable vote system. Number 2, cumulative transferable vote system. According to single transferable voting system, one person has 1 vote. The ballot paper will consist of the names of the candidates. Each voter will give his preference to the candidates. Person who gets quota means cutoff number, is elected. The formula for calculating quota is vote needed to win is equal to total number of vote cast divided by number of directors to be elected plus 1, bracket closed, plus 1. Let me give you an example to explain this point. Suppose 4 directors are to be elected. 6 directors contested the election and the total number of vote cast is 100. If we put these numbers into the formula, we will get 21. That is 100 divided by 4 plus 1 is equal to 21. The 4 candidates who get 21 votes shall be declared elected. If any such elected candidate has more votes than the quota, surplus votes are transferred to other candidates proportionally based on their next indicated choice on the ballot. As per cumulative voting system, a member is entitled to 1 vote for every share held by him for every director to be elected. If a shareholder has 100 shares and the number of directors to be elected is 5, he is entitled to cast 500 votes. Under this system, he can cast all his votes in favor of one candidate, or he may distribute his votes among all or some of the candidates. The 5 candidates getting the highest number of votes will be declared elected. Next method, appointment of directors by the order of the tribunal. The legal provisions in this regard are given in Section 242 of the Companies Act 2013. If the company's affairs are conducted in a manner prejudicial or oppressive to the members or prejudicial to public interest, the tribunal has the power to make order regarding appointment of directors as it thinks fit. And the company shall appoint the required number of directors in the manner directed by the tribunal. The next point is appointment of directors by the central government. Sometimes all the directors of a company resign from their offices or vacate their offices under any of the disqualifications specified under Section 167, subsection 11. In such a case, in the absence of a promoter, the central government shall appoint the required number of directors. Such directors shall hold office till the directors are appointed by the company in the general meeting. So these are the various methods by which directors are appointed in a company. That's all for today. Thank you very much for watching and listening.